No-knock warrants have come under a lot of criticism lately. Legislators have tried to change the laws that apply to no-knock warrant situations. So let's take a look at what no-knock warrants are, their current status, and some proposed changes to the law that we might see in the future. First, let's talk about warrants generally. There are really two types of warrants. First, you have arrest warrants. And of course, these are warrants signed by a magistrate judge that establish probable cause that someone has committed an offense. So it is a warrant for the seizure of a person. On the other hand, you can have a warrant to conduct a search. And this is a warrant that has now established probable cause in front of a magistrate judge, not to seize a person, but to search for and seize items. You could run into a scenario for a no-knock search warrant or a no-knock arrest warrant. So we'll talk about both because the rules that apply specifically to each one of those are a little bit different, even though, as we'll see, the general concepts as to what an officer has to do to obtain a warrant, whether it's a search warrant or an arrest warrant, are relatively the same. Let's talk first about no-knock arrest warrants. Typically, when an officer has an arrest warrant, they're going to follow what's called a knock and announce procedure. That means they'll have the arrest warrant generally in hand. They'll go up to the resident, knock, and announce themselves. And what they're hoping is the person that the arrest warrant is for will come to the door, or someone will open the door and allow the officer's entry into the home. However, there are instances where a police officer might ask a judge for permission to conduct what's called a no-knock arrest warrant. This, as the name implies, means the officers are typically going to take this warrant, not announce themselves, and make forced entry into the residence or the home. Now, the reason the officer would do this is one of two reasons. One, the officer or officers are concerned for their own safety. So they might say things like, we know this is a residence where they keep firearms, and more importantly, they're keeping firearms to protect the drug business that they're conducting out of that home. So if they can give the judge a reason as to why their safety is at risk if they were to announce themselves, then the judge has the ability to authorize a no-knock warrant. An officer might also tell a judge that they have reason to believe that if they announce themselves, evidence could be destroyed. For example, drugs could be flushed away before the officers actually make entry. Now, understand we're talking about an arrest warrant. Nonetheless, the law says they can talk to the judge about the destruction of evidence, because if they were to open the door and in plain view see drugs, as an example, that would certainly be something the officers could investigate. So that's another way officers can establish a reason as to why a no-knock arrest warrant should be signed. Now, typically when we talk about the destruction of the evidence, we see it more related to the search warrants, which we'll talk about in a moment. But a final reason that an officer could establish why a judge should sign an arrest warrant that is a no-knock arrest warrant is fear that the person would escape. Now, the officer has to establish reasonable suspicion as to why they have this concern. It can't be a generalized concern that they have in every single case. But if they can tell the judge something that's specific and rises to the level that's required for all of these different ways to establish, hey, we need a no-knock warrant, which is reasonable suspicion, then the judge can sign off saying, hey, based on the information that's been presented to me, I'm going to allow you to enter without announcing yourself, to make forced entry. Now, notice in all of these instances, the permission to conduct the no-knock entry to get this person was authorized by a judge. And that's what a police officer has to do based on the current state of the law to make entry into the home without announcing themselves to effect an arrest in Texas. Now, if you look at the Code of Criminal Procedure in Texas, there's not a specific section that addresses no-knock warrants. Instead, the case law that's been developed through the Supreme Court and the Fourth Amendment protections that we have against unreasonable seizure of a person or unreasonable search and seizure of items is what comes into play here. And so the case law that's developed through the Supreme Court and now applies to all 50 states is the same thing we follow in Texas. Now, we do have a section of Chapter 15 of the Code of Criminal Procedure that addresses the amount of force that officers can use. Article 15.24 talks about using the amount of force that's required, but not greater than necessary to effect the arrest. In a situation where an officer is making forced entry that's authorized by a signed warrant, then yes, an officer could bust down a door. However, they can't go around tearing up the entire house if there's no evidence that was necessary. It can't be force that's greater than necessary. And we've all seen the news articles when it seems like a police officer has just ransacked a house. And so in those instances, you really have to look at, was the force applied greater than necessary to effect that arrest? And if so, there might be a claim that could be made against the police department. Next, let's talk about no-knock search warrants. Now, this is going to be very similar to the no-knock arrest warrant situation in that the laws that apply are essentially stemming from the United States Supreme Court decisions and the Fourth Amendment protections. So once again, if an officer wants to get a search warrant that is a no-knock search warrant, they're going to go to the judge and say something similar. Hey, we're worried that the evidence that we are trying to obtain is going to be destroyed if we announce ourselves, or perhaps as we make entry to search for those items, we're putting our lives at risk if we announce ourselves. So the judge could authorize a no-knock search warrant. One of the things that is uniquely provided for in regards to search warrants is an officer's ability to break down a door. Now, this is different than the no-knock scenario we talked about, because under the no-knock authorization, an officer can break down a door, make forced entry for either a search or the arrest of a person as long as it was authorized. But there's also provision that applies when it has not been authorized. In other words, there's a law that applies to search warrants where the no-knock provision does not apply or has not been applied for. Article 15.25 of the Code of Criminal Procedure in Texas says that officers may break down a door as long as two conditions exist. One, that they have obtained a valid warrant, not a no-knock warrant, just a warrant. So they have a warrant to conduct a search, and two, they have announced themselves and the person inside has refused their entry. Now, it doesn't say how long they have to refuse their entry for, but the law says if you have a valid search warrant, there's a person on the inside who's not letting you in, after announcing yourself and the person refusing to grant entry, at that point, an officer may break down a door. And it's not just limited to that. The law says an officer can break down an outer door, an inner door, a window, or any part of the house to make entry after they have announced themselves and they have a valid search warrant in hand. That's a very broad law that applies even if the officers did not get authorization for a no-knock warrant. Understand that where this code is found, it applies only to search warrants. No-knock warrants have become a topic of conversation because the execution of no-knock warrants can come at any time, catch people by surprise, who, not realizing that the person trying to break into their house is a police officer, may try to protect themselves using sometimes deadly force. It puts the officers at great risk. It also puts the person inside the home at great risk, because if you have now pulled a weapon on a police officer, they may see you as a threat and shoot you. For this reason, no-knock warrants have come under great scrutiny, and there have been attempts in Texas at a state level to change the laws. Some of the proposals that were made that have failed include setting times when no-knock warrants could be executed so that you're not woken up at 4 o'clock in the morning by someone who seems to be an intruder trying to break into your house. There have also been attempts to require the head of law enforcement for the local jurisdiction to be the one to apply for the no-knock warrant, or to require the involvement of a district attorney to advise on whether getting a no-knock warrant is appropriate or not. All of these measures have failed in Texas at the state level. A number of cities have implemented their own restrictions on when no-knock warrants can be obtained. For example, cities like San Antonio, Houston, Austin, and Killeen have all set up restrictions at the city level that restrict when an officer can obtain a no-knock warrant. So if you're in one of these jurisdictions especially, you need to talk to your attorney about whether the officers followed the proper procedure in obtaining the no-knock warrant in your situation. Thanks for watching. If you found this video to be helpful, be sure to subscribe. We're generating content that responds to questions and comments we receive. So if you have a question, drop a comment below. You can also learn more at versestexas.com.